So, okay.
Thank you.
You're totally welcome. Welcome to the beginner breakout room. I've been talking so much, you've probably heard me. I'm Jessica. I'm one of the co-vice chairs of the committee. I don't know if I pointed that out earlier. You may see my name on the pattern this year. Please don't ask me questions. One, because we're not supposed to talk about the case materials this year, but two, because I actually cannot answer any questions about the case materials this year. I only vaguely remember some of the details. But with me as my lovely co-host this morning is Stacy McNulty. Are you still out of state, Stacy?
Yes, I am actually. So I have been participating with the Texas mock trial as a presiding judge, been helping out with these clinics, for a while now. My family moved to Ann Arbor, Michigan, right before COVID shut everything down. So, but obviously Texas mock trial is like something I really love. I particularly love working with beginners. And so I wanted to be a part of it and help out from afar. I still travel back to Dallas a lot for work and still practice there often. So.
Awesome. So Stacy is going to be leading this section for you guys. But if you have questions, please drop them in chat. I'm going to keep an eye on the chat for you guys for Stacy so that she can just continue leading, and then I'll just sort of interrupt her when necessary to ask any questions. You can also message those directly to me. I think last year Stacy and I ran into this issue where like nobody wanted to ask a question. And so we opened up our private messages, like our DMs, and then we got a lot of questions.
Yes.
There is no dumb question. Every question is a great question, especially because y'all are beginners. Like we understand you don't necessarily know what you're doing. Please do not be shy about asking questions. When Stacy's like, hey, does anybody have a question? You can definitely unmute yourself, ask the question out loud. But if you just really don't feel comfortable doing that, you can message me directly. It's totally fine. So, I did ask a question. If you ask a question in this chat, it will only go to the people in this breakout room, is to clarify. So the intermediate advanced students will not be seeing this chat. It won't be confusing anybody. The chat right now is going to be specific to this breakout room. So with that, I'm going to let Stacy, did you need me to share the PowerPoint or do you have it?
So if you actually, I probably can, but if you could, the one that I emailed you.
Yeah.
And then after that, I have another one, but I may also need to pull up the direct and cross, but I think we'll be good from there. But if you can share the dissecting the case.
Absolutely.
Great. So hi, everyone. While she's pulling that up, I will just introduce myself briefly so you kind of know who I am. I have been practicing since 2010. I do, for the most part, patent litigation and trials, but really any trial or litigation that has to do with technology. Did that for about 6 years at a firm before I went in-house and started managing the global litigation strategy, the trial teams for a technology company. I really like doing that. I also really like, I go to the trial, I'm the corporate representative, but I also work really closely with like our, other witnesses that might be like our, that might come up in our case in chief. I'm sorry, just a second. I also have a toddler who's, he's 4. Who has strep throat. So if I have to take a brief pause, I really, really apologize. What I'm going to plan on going through today for you guys, just so, you don't start feeling like I'm not covering something you want to cover. So I'm going to first talk about kind of, and there he is. I'm sorry, give me 1 second, Jordan. I am really sorry about that. Jessica, could I have 2 minutes and I will get him set up?
Yeah, absolutely.
Sorry, guys.
Yeah, so just to my understanding of Stacey's plan is she's going to go through the basics of dissecting a case, making a plan of how you approach the case, and then near the end we'll get into more like how to ask direct versus cross questions, those sorts of things. But since y'all are beginners, we sort of wanted to go back to the basics of where do you even start? At this point, you should have the case materials. You probably have already started, but if you still feel very lost, hopefully this will give you guys some guidance on what to do. If anybody has any other questions at this time, you can feel free to throw them into the chat or send them to me in a message and we can try to address any other questions that you might have. Especially if you've thought of any other questions about the format, the rules, anything like that, you're welcome to send them to me.
I have a question.
Yeah, absolutely.
So this is literally my first week on mock trial, and I was just handed this, and it looks like there's a lot of internal conflict amongst all the members. But the other thing is, like, I got handed a list of a 50 students who want to be in mock trial. How do you go about like whittling it down to a team, and do you have any extra people that you allow on the team to like help out and stuff like that?
So that's going to be probably a question for some of the intermediate advanced students. But I would say generally, I would start by assigning like one of the witness statements and have people come in and tell them like, oh, if people want to be witnesses, for instance, have them memorize maybe the first page and then ask questions and see who actually took the time to memorize it. That's going to be step one, who's actually committed. And then for attorneys who feels comfortable actually asking questions and that sort of thing. If something isn't specifically clarified in the fact statement, can we make it up? Only if it really does not affect the case, but generally speaking, no, you got to stick to the facts of the pattern. Yeah, and I think, yeah, Stacey's answering one of the questions in the chat. Okay, Stacey's back. I'm gonna let her take over and get back to the plan. Welcome back.
Sorry.
You're totally okay.
Okay, so just to give a quick overview of kind of what I'm going to try and cover today so that you can feel or know that I'm going to cover some things, because obviously questions come up and there's a lot to cover. So first, we're going to talk about kind of how do you have all this information? We have all these materials, all these rules. How do we even begin? So we're going to talk about how you read the case and the materials, how to sit down and make a plan and kind of put together your outlines for presenting your case and standing up at trial. So that's going to be kind of the first part. And the second part, we're going to go through direct examination, entering and using exhibits as evidence, and then cross-examination. So that should give you kind of the big important parts that you're going to need to get started and put on lovely trials. Okay. Oops. Okay, so next. Can I make it go to the next, or are you doing that, Jessica?
Since I'm the one presenting it, I have to do it, but you can just yell at me.
This should be fine. Perfect. Okay. So you got, I'm going to be working with the sample case that we have. It's different from like the case that you'll use at the actual competition. But you get handed a packet, right? Where do I even begin? So the most important piece, and you should start there, you should end there. It should be the first thing you memorize and want to know about the case, is the elements of the cause of action. So in your packet, let's see, there's the stipulations of the parties, blah, blah, blah. I go to page 2 and it lists out the prosecution must prove the following elements beyond a reasonable doubt. The defendant intentionally caused danger to the public by causing persons to be in fear for their lives by blah, blah. So I'm going to go through that in just a minute. But that's the most important piece, because that is what the prosecution has to prove. That's what the defendant wants to disprove or show the absence of. All the evidence needs to be relevant to that, proving the elements of that cause of action. Otherwise, that's what the judge and jury have to decide. That's really what everything is focused on. So there are going to be facts that are kind of completely irrelevant to that. And just know that that can happen. After you've looked at the elements of the cause of action, okay, we kind of know the framework that we're looking at. Then start reviewing the witness statements, all the materials that you have. So in our sample case, we've got the stipulations of the parties. A lot of that is procedural stuff, but stipulations also mean like agreements. So there typically will be some things that the parties have agreed to. So for example, you might agree that X happened in public. Everyone agrees. That would be an example of a stipulation where you don't really even have to prove it. We just all know that that's been checked off and agreed. Then we have the witness statements. So in the sample pack, we have, I believe, 2 witness statements for the state's witness, and then 2 for the defense, and then let's see, a code about respect for the flag. So you're going to review all these things so you know kind of the world of what's out there, and then focus on, if you're the state or the prosecution, you're going to review kind of your witnesses, reread their statements. And then if you're the defendant, you're going to reread statements of your witnesses that you'll be putting on. So first elements, cause of action, then kind of get familiar with the facts. All right, next slide. So this is the elements of the cause of action. This is the actual penal code language that's listed in there. So if you haven't reviewed this yet, I'm going to go through it today. So it is an offense to intentionally cause danger to the public by causing persons to be in fear for their lives by igniting a fire in a public place, or shouting fire in a public place, or being on fire in a public place. So that is the actual statutory language. Next slide. And what I did here is just kind of transfer that into kind of shorthand elements that the prosecution is going to need to prove. So we have to prove that the defendant did this intentionally. So intent, state of mind, is often very important in criminal cases. Causation is number 2. So he had to have intentionally caused these things. He caused people to fear for their lives. So it's important that we note here that the people had to fear for their lives. They couldn't just be afraid or shocked. They had to actually fear for their lives, and that had to be caused by the defendant's acts. Next element is this public fire element. So there's the 3 options: by starting a fire, by shouting fire, or by actually being on fire. And then by virtue of all these things, cause danger to the public. So those are kind of the short form of the elements you should keep in mind in this sample case. This is what has to be proven. If the prosecution or the state cannot prove all of these things, then they are not going to get a conviction. On the other side, the defendant will want to discredit or show the absence of any of these things. For example, showing people did not fear for their lives, or showing that although the defendant intended to set fire to things, he did not intend to cause people to fear for their lives, and he didn't intend to cause any danger to the public. Okay, next slide. Oops. Okay, so here I just kind of made some notes about, and as you're kind of going through and looking at the elements, these are the kinds of things you should think about. So, you know, I made a note, you know, it might be difficult to prove that the defendant intended to cause people to fear for their lives. Did he actually cause people to fear for their lives? Did people actually fear for their lives? Did the fire occur in public? And then did the fire element cause danger to the public? So those are just kind of some notes that you should do the same as you're going through, you know, any elements of a cause of action, regardless of which side you're on. Next slide. Okay, so all of these elements that we've been talking about, they have to be proved with evidence at trial. There's testimonial evidence, so there's witnesses that come and testify about things they know, saw, heard. And there's documentary evidence, physical evidence like records, notebooks, a burned flag, perhaps. Okay, next slide. Okay, so here's some examples for the state. Next slide. Next. Okay, so this is kind of the way that I like to do things, and you know, other practitioners may have different ways of doing it, but for me, like mentally, this is the way that I get there. So for each element, I ask like a how do we know question, and that always like tells me that I'm getting this proof. So how do we know that, for example, the defendant intentionally started a fire? Okay, he had to have intentionally meant to do that. So the answer to that question, after we read through all the materials, the witness statements, things like that, the answer to that how do we know question is going to be the evidence that I'm going to need to use to prove that element. So it might be a witness statement, it might be like a video. There's often more than one way to establish an element or prove an element. So you should think about and be ready to do it in multiple ways. Sometimes, for example, there will be an objection to a piece of evidence or a line of testimony. And so you need to be prepared to prove that in a different way. Okay, next slide. So after we kind of go through the some of the fact statements here, so I just kind of went through and answered this question. So how do we know that the defendant intentionally started a fire? So if you look at the witness statement for Nikki Romanov, she testified that she turned and noticed that that crazy person had set fire to the flag of the great state of Texoma. So that is something that by her witness statement, she personally saw that that person had done that. So that's some testimony you could use during her direct examination. You know, you put her up on the stand and you want to establish that she saw the defendant, you know, light the flag on fire. There's also other witnesses that could do the same thing. So Polly Potemkin, that's actually a witness for the defendant, but she can testify that she saw the defendant light that flag on fire and he meant to do so. That was a part of his magic trick. You know, if you're the prosecution, there's multiple ways to establish this. It's going to come out in the course of questioning, but you want to make sure that you are asking the questions both in direct examination of your witnesses, but also, you know, the state should be asking Polly Potemkin, this witness, during cross-examination to just make sure that there's no question about that. You know, so you saw the defendant intentionally light the flag on fire, didn't you? Yes. And that was part of the magic trick. He meant to do that, didn't he? Yes. Good, move on. So there's multiple ways to establish it, but you should, when it's something important, you know, you need to try and do it as many ways as you can. All right, next slide. So now kind of we're going with some examples for the defendant where you want to disprove each of these elements, kind of came up with some samples here. So next slide. There again is the, thank you. Okay, so the defendant is, when you're looking to do this, first the defendant is going to want to look at their own witness statement. So there's two witnesses that the defendant will put on. You're bringing these witnesses, they are part of your case. So in theory, they have good things to say for your side. And you can, to some extent, control or make sure that that evidence gets out there. So after reading those materials, ask, what tells us that the defendant's fire did not make people fear for their lives? There was fear, they didn't fear for their lives. So what kind of evidence do we have that tells us that? So our answer is what we're going to need to prove in court. And there may be more than one way. Next slide. So I went through and kind of answered the question. So what tells us defendant's fire didn't make people fear for their lives? Or even if they were afraid, they didn't fear for their lives. So the defendant's witness, Polly Potemkin, I believe that's the magician's assistant, said that right after the trick, there was a gasp from the audience, but the gasp wasn't, a fearful gasp, but it was more surprise and anger that the defendant had burned a flag of Texoma in the governor's office. And there's actually, Polly heard someone exclaim in anger following that little gasp. So, she heard and observed these statements and the reactions of the audience. And those things that she heard and observed told her that these people were not afraid for their life. They might have been angry or, surprised, but they weren't afraid they were going to die. Another way you can establish these kinds of things that are helpful for the defendant is kind of showing that like something didn't happen. So, if there's a fire and people are afraid they're going to die or, fear for their lives, they're probably going to run away, or they're certainly not going to run toward the fire. Another way to kind of establish this throughout witnesses is to establish kind of where they went, or that none of them ran away from the defendant or the fire, as anyone would do. So, for example, right after the magic trick was performed, the governor ran toward the defendant to yell at him. He didn't run away, which, if you were scared for your life, you're not just going to go yell at someone. You're going to run away and save your life or the lives of others. Another witness, so the state's witness, so this would be something that would come up during cross-examination. Nikki Romanoff, she explained that she was in shock, but over the desecration of the burning of the flag, not that the fire put her in mortal danger. She explained exactly why she was shocked after the magic trick, and it was because of this desecration of the flag. So it would be important to, on cross-examination, you're asking Nikki questions, say, now, you testified that you were shocked because of the desecration of the flag. Is that correct? Yes, I was so mad about that desecration of the flag. You weren't scared for your life at that time, were you? No. Or you didn't say you were. No, I didn't. You said you were mad, didn't you? So, just establishing clearly that none of the people who had immediately observed this fire were afraid for their lives, or nothing that they did told us they were afraid for their lives. Next slide.
Stacy, there's a question in the chat. Is there any way the defendant can be guilty of all the points but still be innocent?
No, not in this sample. So here, it's a pretty straightforward. If all the boxes are proven and the jury finds that each element has been proven beyond a reasonable doubt, then the jury is going to have to find the defendant guilty. In, you know, the way that these types of things work is sometimes there's an affirmative defense, there's this, that, or the other thing, but that is not the case here.
And I'll also, I guess, just sort of take a step back towards how we score. The judges who are scoring don't actually render a verdict of guilty or innocent.
Right.
You are given a score based on each phase of the trial. So there's a score for your opening, a score for your closing. Each direct and cross gets a score, and the witness at that time gets a score. So there's 11 scores for each side. So it'd be, you know, 1 opening, 1 closing, and then 3 crosses, 3 directs, 3 crosses, and 3 witness scores for each side. And so this goes into what your score is going to look like, because if there's, if you're crossing Nikki Romanoff, for example, and you don't ask her, was she actually afraid, you know, you may not get full points because you've really missed something as the defense attorney that could really help bolster your case. And so just want to take it back a little bit to like how you're actually scored. But in real life, if you're guilty of each and every count, you're guilty.
Yes. But I think that is a good point that Jessica brought up, is that, you know, sometimes, and I think maybe this sample case, you kind of went, you know, there's clearly one, you know, it looks to me like this side's generally going to win just with the facts given, but that really doesn't matter when we're scoring you for purposes of the competition. And oftentimes I have seen and scored myself where one team will win, you know, their advocates were fantastic, they made all the points, but oftentimes, you know, an attorney from the other side will get best advocate or best witness, things like that. So just because you feel like you didn't actually prove all the elements as the, you know, the state, doesn't necessarily mean that you are not going to win the advocacy component of this competition, because that's really what it is, the advocacy part.
And I will say, in your closing argument, you want to pretend that you did in fact prove each and every
Yes.
element as the prosecution. Even if you're sitting there going like, oh, I think they poked a lot of holes, you still present it as like, there were no holes poked. As you can see today, it was exactly what we told you it'd be. So are you ready for the next slide, Daisy?
Yes. Okay. So actually, that was a great segue when we're talking about opening and closing, is creating a theme for your case. So we just talked about how you looked at the elements of the cause of action and you kind of looked at the facts that you've got that are going to help you prove your case, or in any sense disprove or poke holes. So now we've moved on to creating a theme for your case. And this is kind of the story. This is what holds it all together. So I like to think of a case theme as like a short, memorable phrase the jury can remember, or your elevator pitch. So you guys probably are not old enough to remember the O.J. Simpson trial, but the phrase that came up was, if the glove doesn't fit, you must acquit. And OJ went to try on the glove, bloody glove, and it did not fit his hands. And that was the big murder weapon, the blood on it, and it didn't fit his hands. There's no real way he could use it. And so the jury had to acquit. You know, that was the phrase, and the jury took that, and he was acquitted for the murder. So now this is not the best, but for our sample case, I was kind of trying to think of like a little phrase I could say, and I thought, birthday party magicians are not life-threatening. Do not invite a life-threatening person to your kid's birthday party. It's just not true. So that's kind of like an idea that you can, that's going to bring all of your case together. Some people have them, they're very cute, you know, cute little phrases, or funny, or, you know, kind of like a commercial, but it can also just be something like one sentence, you know, no one was afraid of the fire. That works too. So as is the case with kind of trial advocacy, or just kind of advocacy in general, you tell them once, you tell them again, and then you tell them a third time. So you're going to introduce your theme during opening statements. Opening statement is when you get to introduce your primary idea and tell the jury what you're going to show them. So we're here, the prosecution is going to prove that the defendant did all these things to cause public danger, blah, blah, blah. They will give their theme, and you, during opening statements, you tell what you're going to show. You're going to hear from this witness. One important thing about opening statements, you can say, you will hear from X, talk about a witness. Do not promise or do not say that the jury will hear from a witness that you can't confirm will be able to say those things. So really you should talk about your witnesses that you're going to put on. If it's very sure that some statements will come in from the other witness, you can say it, but just be careful because you really don't want to overpromise. You don't want to say, you're going to hear from this police officer that he saw all these things and heard all these people. And if that evidence is not admitted at trial, if he's not allowed to answer that line of questioning, well, you're going to look pretty silly. And overpromising is never good with a jury. So you introduce your theme during opening. You're going to revisit your theme during directing cross-exam. So you don't necessarily have to say the phrase, but if you can, it's great. But you want to allude to it. For example, if I was doing cross-examination, it would be great to, when I'm talking to the governor who hired the magician for his daughter's birthday party, I'd say, well, you hired this birthday party magician. And birthday party magicians, they aren't life-threatening. You didn't hire guards around this magician, things like that, just to say, like, and you did it because it's a safe activity for a party, right? Yes. So those are the kinds of things that if you can make the other side's witness say or agree to, that's great. Because then during closing statements, you can say, you heard from the governor that, birthday party magicians are not life-threatening. He wouldn't have hired a life-threatening person to perform at his daughter's birthday party. So that's just a way to keep harping on your theme. All right, next slide.
Yeah, and I will add to that, Stacy. Yeah. When you say make sure you're not promising what the other side may or may not testify to, yes. I think the one exception is when there is compensation involved in the testimony. I think that is something you should be bringing out in your opening is, and I want you to listen carefully when Jane testifies, and specifically pay attention to whether or not Jane is being paid to be here today. And because if the witness is following the rules of the competition and they are asked, are you being paid to be here today? They will say yes, truthfully. That's not one of the questions that you can really wiggle out of. And so those are some of the things you can also include in your opening statement.
Yes.
Without like necessarily promising what they will or won't say, you can still say, listen carefully to their testimony about what they actually saw versus what they heard about or things like that.
Yeah, exactly. And I liked what you said there too. I think it's always really important, or it's really effective during opening and also again during closing to, if there's one thing that's a really critical piece of evidence, tell the jury that, say, and I want you to pay particular attention, pause like a teacher, here's an important thing, flags, look at this. That's very important. And that's a good thing to do.
Yeah.
All right, next slide.
Can I give one example from last year's pattern?
Yes.
There was a witness for the defense who made literally millions of dollars off of the insurance investigation. And there were not enough people who brought that up in opening or closing from the plaintiff's side to say, hey, the defendant's witness over here made literally millions of dollars to have this position. And not enough people said that in their opening or close. And certainly not enough people were saying that in their cross-examination of that particular witness. I saw one team do it really effectively and they got extra points because it's like, finally, somebody checked that box for me. And so if there is something that's super, super, super critical and you've missed it entirely, you're leaving points on the table.
Okay, So we talked about kind of creating a theme. Here's how I go about actually putting together your case presentation. So you're going to create an outline of proof of these elements and then kind of loose scripts. Next slide. So we go back to those elements of the cause of action that we listed out there. And so, write that down. Sorry, give me 1 second.
Okay, I'm just going to take this time. If you think you are in the wrong room, you can just send me a message and I can move you over to the other one. I've already had one person tell me that. If you feel like you maybe should be in intermediate advanced, I can definitely move you to the other breakout room. But if you feel comfortable here, please stay here.
I'm sorry about that. Like, how many times can a toddler grow up in one morning? Okay. Everyone with me? It's good. Okay. So when I go through, I'm making an outline of the elements of the cause of action that you need to prove or disprove. And so under each element, list out your proof. So that's going to be witness testimony, exhibits, and then also witness testimony you can bring out during cross. So, excuse me, the reason that I separated witnesses direct testimony, because that's going to be like your witnesses that you are bringing who will affirmatively say these things and you know that they will, versus cross-examination, where if you've done right, you can get the witness to say the things that are in their fact statement, but you just kind of never know. So those are different types of proof. The other thing you're going to want, you also need to be familiar with the other side's proof, how they may discredit like your witnesses, how they're going to poke holes in your argument. So this is something that you should always be thinking about. But for the first steps, you're going to make an outline of your proof for the elements. Next slide. So now that you have kind of the witnesses, the testimony listed and the exhibits listed that are relevant to each point, you're going to start making basically a script for your witness, or a loose outline of what your affirmative witnesses on direct examination, what they're going to talk about. So they all kind of tell us a story in their fact statements, and you're going to basically go through that. But the most important part, and where you should, have your questions memorized, are the questions that are going to establish the elements that you need to prove. So, and then then what did you see? Did the defendant light something on fire in a room of people? Oh my goodness. You are also going to, so those questions are important to have written down, kind of scripted out. And you'll also want to plan on what exhibits you'll want to enter and use, and kind of the foundation questions that you're going to have to ask to get those admitted. The other part about a direct examination that you'll want to think about is called kind of taking the sting out of weak points, or explaining something that might sound bad. There's considerations about, do you do it during your direct examination, or do you wait until later? And so that's something that you just kind of have to talk strategy with your team. One example of a good time to take the sting out of something is if, for example, one of your witnesses gives like two, and you see this a lot in the mock trial, like the actual cases, a witness will give two statements, one later in time, and the one later in time changes a fact that they, testified about. So, it'll say, I was thinking about it more and I, realized that I misspoke and it was actually the 12th of May instead of the 10th. And so that's the kind of thing where there's a lot of benefit to taking the sting out of it. You really don't want to have your witness tell their whole story, get out these elements, and then on cross-examination, first thing the other side does is essentially call your person a liar. Well, hey, didn't you change your story? So which one is it? That kind of, those kinds of questions. And, but if you kind of ask about that first, before the other side has a chance to go into that, it really kind of takes the sting out of their questions and doesn't make it sound quite as bad. They're still going to make the points, I'm sure, but that way you're not losing as much witness credibility by having it come up for the first time in cross. So after I'm kind of making these direct exam kind of scripts, for me, that's when I then write the opening statement, because that's when I can say, well, here's the things, here are the pieces of evidence the jury is going to hear from my witnesses, So, we have, as the state, we have to prove these elements. You are going to hear from this person, and she will tell you that she heard people screaming, things like that. So once you've kind of outlined what evidence you have and testimony you have, then you can write your opening statement that points out some of those key pieces of evidence. Then next, I like to make the cross-examination scripts. And that's where, you're reading through the witness statements of the other side and you're trying to poke holes, you're trying to discredit them, or establish points that they would agree to that you can make that will help your case. So we'll talk about cross-examination a little bit later, but I'm just kind of talking about like my process. And then the last part is writing your closing statement. And this is the thing that always comes last. It's going to mirror your opening statement because that theme's the same, right? Magicians are not life-threatening. That should come up again in your closing statement if you said it in your opening statement, and that's what you've been talking about the whole trial. That should absolutely be something that you bring back full circle during closing. The reason that I like to wait to write the closing statement last, or at least parts of it, is to actually address testimony and facts and statements that were actually heard during the trial. Like we talked about before, you don't always know like what is going to, what the other side is going to bring in, or what, evidence might come in or not. So it's very powerful, and judges, I think, give you a lot of credit when you stand up in your opening statement and you can actually say, reference something that did happen in the trial. So, you heard from defendant's witness and she admitted that blah, blah, blah. You heard her in court today say this. That's a very powerful way to bring things full circle in your closing statement. Okay, next slide. Okay, so that's these are just kind of questions about the process and the overview. Do you guys have any questions about that part? Otherwise, I can just move on to like the direct and cross. There might be some in the chat. Hold on.
I haven't seen any in the chat,
Okay.
and I haven't gotten any messages, but if anybody has any questions, or if you think of the question later, you're welcome to stick it in and we'll find a way to answer it for you, even if it's sort of out of order. So
is it all right to ask a witness a question that's not explicitly stated in their testimony, but can kind of be alluded to from their tone? For example, if someone was a little frightened during that magic performance, but they never said it, could you ask them if they were frightened?
So when it goes to something that's like directly, this is like an element that's disputed, is whether people were frightened or feared for their lives. If they didn't say specifically like I was frightened, probably shouldn't ask, because that's going to be kind of outside the scope of what the witness actually said.
Okay,
You
thank
can
you.
say something like, oh, you gasped, didn't you? That definitely alludes to the fact they might have been frightened, but you're not actually asking something. You're not asking them to confirm a fact that is not in that record.
Right. And then I think on the same side, if there was another witness who perhaps saw that witness gasp, but also said she was also shaking. She see
Yes.
the look on her face. She took a step away. Like you could definitely ask another question, a witness about somebody else's behavior, even if that other witness never admitted to being afraid. You can present other evidence to support that maybe they actually were, and they're just not telling the truth. Can you explain how information not brought up in direct cannot be brought up in cross, even if it is in the witness statement? So I will say, according to our rules, we actually don't follow that. The cross does not have to follow the direct. You can get into other things that are, unless that isn't true, it's how our region has been competing. I will say, I've been a presiding judge, and Stacy, you've scored and presided and all of that, and I don't believe that's in our competition rules. Your cross can go outside the scope of the direct.
I will say that like redirect and recross cannot go outside of the scope of those. So like recross cannot go outside of the scope of redirect. But I think that's a little bit different of a situation.
Yeah. And going back to the example of the paid witness earlier, like if on direct, they don't ask a single question about compensation, you're absolutely entitled on your first cross to get into the compensation of that witness.
Yeah, that's a good example. Cool.
That's a great question. Are there any other questions about this part of it before we move on to the next slideshow? Okay.
Okay, can I share now?
You should be able to share, yes.
Where? One second. Give me 1 second, sorry guys. Okay. Okay. Can you guys see that?
I can see it.
Okay. It says examination and entering evidence. You guys got that?
Yep.
Okay. So there's direct exam and cross exam. That's what we're going to focus on today. So we're going to start with direct because that comes up in your case in chief. These are direct examination is what happens when you bring your witness to the stand. So, you know, during the plaintiff's or the prosecution's case in chief, the prosecution will call its witnesses and then we'll give direct examinations. One thing I'll say about direct examinations is when they're done well, they're very, very effective. I think that cross-examination always feels like the fun part that everyone wants to do, but when you can do a really good direct examination, it's very effective and you get just as many points as you do for doing an effective cross. Okay, so the purpose of this is to have your witnesses tell their story and establish those important points that are necessary to prove your case. I think one of the biggest takeaways that you should just remember is that during direct examination, You, the attorney, you are not the star of the show. You really are taking a backseat. The witness is the star of the show. They should do most of the talking. The attorney is there to just ask questions that are kind of like guideposts to make sure that the witness is getting to the topics and saying those things that we need them to say to establish the elements of the cause of action. So I think the good thing about direct examination is that you can really, write it out for yourself. This is something where preparation can get you there, because you have control over what you ask them. You have control over how much you prepare and write your questions down ahead of time, as opposed to cross-examination where you don't have as much of control about how a witness, what they've already said and how they're going to respond. So questions should be formatted this way. They are who, what, where, when, why, and how. If you just keep that running in your mind, you can come up with a question that will get you there. Sometimes I also think of did, like, did you see something there? That's also one, but format your questions, who, what, where, when, why, and how. How did you know? That kind of thing. Those types of questions are what that will allow you to guide your witness without, taking front and center. Because when you start saying, and then did you run into the room next? That doesn't give your witness the opportunity to tell that part of the story. It's technically leading, but really it's not letting your witness tell the story. So the key here is that all these questions need to focus on what your witness had personal knowledge of, what they saw, what they heard, what they observed, what they know. That's how you get there. When you're preparing, you're going to want to prepare your questions, kind of your loose script with your witness, so that your witness understands the points that you want to get across, and you and they understand kind of the flow of questions, where you need to go, so that kind of when they forget what they're supposed to say next, you can just gently, prompt them, like, did you hear anything? And then they go, oh yeah, I'm supposed to talk about, like, I heard a loud sound, something like that. Like I talked about preparation being key, you should know how your witness will answer the questions. The answers are all in their witness statement. So there should be no surprises here. I think one place as a judge where I see teams go wrong is they just want to tell this story and the witness just wants to show that they've memorized a lot of things. That's great, but it's much more important. Time is limited. So tell the story, but focus on the key elements that are necessary to prove your cause of action. We did talk about taking the sting out, and that's something that you can do, during the course of a direct exam. So here's just some examples of like how to start, because I think sometimes it can be awkward. But they come up, this way and say, hi, what's your name? For example, like the first state's witness is Alex Kerensky. He's the colonel of the governor's guards, just to remind you. But I would say, well, hello, Mr. Kerensky. What do you do for a living? And he'd say, oh, I'm the colonel of the governor's guards. We protect the governor of Texoma. Oh my, well, how long have you been colonel? That's a way to kind of establish his background, give him credibility for, and kind of set the stage for his testimony. Sometimes I say, why are you here today? With someone like this, where they're saying, well, I arrested this defendant for this. I'm going to talk about it. I also sometimes, when did you first meet the defendant? Okay, well, I first met the defendant when on this date, when I got a call about a fire and, at a birthday party. Why did you arrest the defendant? things like that. So those are like little guideposts to, make sure you're getting through the story, establishing, who this witness is, what they saw, what they heard, etc. With direct examination, especially with a witness like this, you are going to get into some nuances with rules of evidence and hearsay. It's kind of outside the scope of what I'm going to talk about right now, but it's important to the extent you can focus on what the witness saw and heard, as opposed to what someone told him. With a police officer or someone like this, a way to get around hearsay is to say, why did you go to the Governor Gwynn room? Well, I got a phone call saying that there was a disturbance there. That's why I had to go. Okay. What did you see when you got there? So that's focusing really on what he did, what he saw, why he did things he did, rather than like what other people have said outside of court. Okay, so this is one thing that I think you can, direct examination and then establishing foundation and entering evidence. These are things that you can memorize and feel comfortable and get some points on the board. So this is, we're talking, we just went through, your witness and their testimony that's being offered as evidence, but we also have records, documents, things like that you also want to enter as evidence. The more evidence you can use and enter, and show the jury, even if it's not like the best evidence, to show the judges that you can do that properly and following the rules and procedures, that is going to get you points. So if you look through your whole case plan and you haven't offered any documents in evidence, figure out how to do it. And I'm going to go through how. Okay. So we talked about how witness can only testify about things they have personal knowledge about. Well, that's true about documents too. They just can't talk about a document they've never seen before and have no knowledge about. So the best time to introduce and use evidence like documents is during direct examination of your witness. Don't be afraid to do it during cross-examination. You'll definitely get points for doing that. But the time where you can plan the most and do it probably most cleanly is doing direct examination of your witness. So what you're going to do is you're going to ask questions to lay the foundation for the document, establish that they have personal knowledge and that the document has meets the credibility requirements established by the rules of evidence, which are a little bit outside the scope. But you'll ask these questions and then you'll go through this process of entering the exhibit. And this is mock trial rule 4.20. Just memorize this. Just memorize it and practice it. It's written out in the rule. I've copied most of it here, but I'm going to go through it with you right now. Your Honor, may I approach the witness with what has been marked as Exhibit A for identification purposes? So what you're doing is you're asking the court if you can show that exhibit, if you can walk over to the witness and show it to them. The judge will say yes. Show these, before you do that, you show a copy to opposing counsel. I like to provide them with a copy. I was looking at these rules and they didn't say that you had to give them a copy, but I think it's just a good practice to do that.
Well, I think most teams, Stacy, will already have all of the exhibits printed out since you're playing both sides of it. And so instead of having to have 300 extra copies,
actually hand them over.
I normally just recommend that you show it to them just so, and again, there should never be a question as to what exhibit you're showing them. They're just looking at it to make sure, oh yeah, that is exhibit 3.
That is what it is. Mm-hmm.
Yeah.
So the judge says that you can approach the witness. You've shown the exhibit to opposing counsel. You can say something fancy like, let the record reflect that I am showing Exhibit A to opposing counsel. It might make you feel good. You don't have to, but you can. Then you give the exhibit to the witness and ask them to identify it. So what you want the record to say, so if someone's reading this later, you want them to know what document you gave the witness, and you want to show that the witness knows what it is and is telling you. So I am handing you what has been marked as Exhibit A for identification purposes. What is it? I think that's the easiest way to say it. You can say, can you identify it for me? But be very clear with your witnesses that they're not supposed to go into a long discussion about it and how it relates to other things. They're simply identifying it. So an example that I'm going to get into in just a minute is if it's like an accounting ledger. This is a Company C accounting ledger. Great. So then you've got to ask questions to lay the foundation for admissibility. We've got some examples. Those are going to be in the rules of evidence, but generally speaking, you're going to have to establish that the witness has personal knowledge of whatever is on the document or whatever is on it, and that it is similar or substantially similar to what it's purporting to show. So I'll go into an example later. Once you've gone through those questions with your witness, you will offer the exhibit into evidence with the court. Say, Your Honor, we offer Exhibit A into evidence. The court will ask opposing counsel if they have any objections. Sometimes they do, sometimes they don't. Those will be handled. The court will direct that. So, for example, if the other side says, object, this is, more prejudicial than probative and shouldn't be admitted, the court will say, okay, response. You can say, it's not prejudicial. It's very relevant to the defendant's intent to cause people to fear for their lives. And so, it should be admitted. The court will decide. Sometimes the court will ask for further, responses, but often they don't. Then the court will say the exhibit is or is not admitted. If it is admitted, go on asking your witness about the contents of the exhibit and you show it to the jury. So sometimes you can make a big deal about it. I'm going to now publish it to the jury, and you basically hand a copy for the jury to look at. So if it's an important document with lots of details, I want to do that. But you can show it to the jury, and then you can ask your witness questions about it. So that's when you can actually get into the contents. If you want, if it's important to show that there's some mistakes on this accounting ledger, oh, can you show me, do these numbers all add up? No, well, where are the numbers wrong? What are you seeing? Things like that. That's what you're going to ask your witness about. Let's see. Oh, okay. So I wanted to do one example of a business record. So a witness with personal knowledge must establish that the record was made as a part of regularly conducted business activity. It was made at or near the time of the relevant event, and the record is in the same or substantially the same condition. So here's an example of, in that process where I had to lay the foundation, ask questions to lay the foundations. This is where I would need to then ask questions to establish those things. So here's an example. In this example, Exhibit A is an accounting ledger for Company C, and the witness is an accountant for the company. So as the attorney, I'd say, I've handed you what has been marked as Exhibit A. What is it? This is a Company C accounting ledger dated November 1st, 2021. Does Company C regularly make these types of accounting ledgers as part of its business? Yes. Well, how do you know that? Well, I am an accountant for Company C. Was this accounting ledger that we're looking at created at or near the events of October 2021? Yes, it was. It says here it was created November 1st. And is this document in the same or substantially the same condition, you know, as you see them, basically? Yes, this looks just like our accounting letters. You know, here's the logo. This is exactly what they look like. Great. We've laid the foundation. Okay. So that's one example. That's you know, laying the foundation for other types of documents are important. The other kind that you might see that I did not go into in this presentation here, but are demonstrative exhibits. They it's something like a map or a drawing or a picture that the purpose isn't to establish like some truth, but it's to allow to demonstrate something that the jury would want to see. So a good example is a map where, you know, to lay the foundation with your witness, you'd say, okay, what is this? It looks like a map or a rendering of my house. Okay, and are you familiar with your house? Yes, it's mine. I've lived there. Is this the same or, you know, substantially similar to your house as it is on that day that these things happened? Yes. Okay, great. And so then when you use a demonstrative, yes, you know, ask for it to be entered. But the good thing is when you're going to publish to the jury, or you can like put it up on an easel or something, and then ask your witness to show like, where were you then? Oh, now where was this person? So in other, you know, in our sample case, there's not that kind of evidence here right now. But in many cases, in almost all mock trial cases, you're going to have something that can be used as demonstrative evidence. Oftentimes, then, if someone has an objection, you can just say, we're only offering it for demonstrative purposes, and the witness has testified that it substantially resembles what it's trying to show, the map of my house. Just if you can enter and use demonstrative exhibits, that's a really, that will get you points. Okay. Cross-examination. I don't have a lot of slides on this, but cross-examination is, oh, there we go. Sorry. Okay. Okay, I'm going to stop sharing. You can see my crazy family. Here we go. Okay. I will also circulate these slides and then another deck of slides that we have from another attorney who put some together about direct and cross. But so cross-examination is, the difference here is that you are the attorney, you are the star. You are asking yes and no questions, very simple, closed questions that invite only a yes or a no. This is really the fun part, because this is when you kind of get to get a witness in a corner and get them to say something. And this is where in all the movies and TV shows, the exciting stuff happens. So basically you're preparing the same way. You know, you should be familiar with your other sides, the witness statements. And so what I will say as a practicing attorney during trials is look at you know, you have the witness statement. So if you're preparing to make a cross of that witness, pick a couple, 2-3 points, maybe there's 4, that you want to establish from that witness. Make those points and be done. Sit down. The hardest thing to do sometimes is to know when to sit down. You know, for the defendant's counsel, looking at, you know, Kerensky or Nikki Romanov's, you know, a good point to make. So Nikki Romanov was in the room, and she's one of the people that said, you know, she heard a shocked gasp, and she was in shock at this desecration. She tells you that she is upset about the flag being desecrated. She says nothing about being afraid for her life. She called for the guards and wanted him arrested. She would like to have seen the traitor drawn and quartered. She was mad. She wasn't afraid, she was mad. So that is one point that you absolutely need to make on cross-examination. You can, to keep it to yes and no questions, I suggest quoting or using like her language from her statement, or very simple language, didn't you? You were in complete shock at the desecration of the flag, weren't you? Yes or no, you were mad about the desecration of the flag. You weren't scared for your life, were you? And then the witness, honestly, they're kind of stuck because it does not say that in their fact statement. So if the witness says, yes, I was, that's a lie, and that's a violation of the rules. And, all they can really say is no, or yeah, I didn't say that. So, then you can kind of harp on that. Well, if you're afraid for your life, wouldn't you have said that? Wouldn't you have told the police officer that? Things like that. So the key for cross-examination is yes or no questions, being clear on what points you want, cross points you want to make that either help your case or discredit the witness, and then be done. Because what we see sometimes is that it's fun to just like argue, and that's true, but it's not always helpful. And sometimes you get with a witness where they're not going to say what they should say, or questions not phrased perfectly, so they can kind of skirt around it, and it's not really helping the jury, I guess. So as an advocate, the best thing to do is to try to rephrase your question to make the point in another way. If the point is just not being made, move on to make another point that you can make. If it's kind of going south at the end, revisit a point that you already made well previously. That's what I like to do. Often they might object to asked and answered. Okay, fine. But that's not embarrassing to get. So cross-examination, the key is to control your witness.
Stacey, before you get on to controlling the witness,
Yeah.
I just want to highlight the question in chat was, it sounds like
Okay.
we're asking leading questions, and I said, you're allowed to lead on cross.
Yes. And so when we say like control the witness, ask closed yes or no questions, lead away. Like you want them to answer the most narrow, specific question that you ask, because otherwise they're going to have wiggle room to explain what they want to explain, and that's not what you want. So absolutely, yes, please lead.
And I saw a hand up. Alyssa, I'm not sure if you put your hand up by accident. Did you have a question?
Yeah, it was by accident. Sorry.
Okay, that's fine. I just wanted to make sure we're taking in time to answer questions as we go along. Okay,
Yeah,
thanks,
thank
Stacey.
you. Okay, so yes, thank you guys for asking those questions and clarifying that. Lead away. Yes or no questions. So now the hard part sometimes can be getting a witness, controlling a witness and making them answer yes or no questions. And so this takes a little bit, you've got to be delicate with it, but when you can do it right, it really helps you in terms of advocacy, because you will be reasonable and fair, and then the witness looks like crap if you try, you're like, listen, buddy. So the way to do that is, let's say I ask a question. Let's say I'm cross-examining Nikki Romanoff, and I'm trying to make the point that she was not afraid for her life, and that she was angry, right? But the witness just doesn't want to admit that she wasn't afraid for her life. She's just not going to go there. She thinks it's bad for her team. So, I say, well, you weren't scared for your life, were you? And she goes, I mean, I didn't say that, but okay. In your witness statement, did you ever say you were afraid for your life when you saw the fire? Well, no, I didn't, but here, and that's when you can, it's your judgment. You can either let them keep going. That could be problematic sometimes. Or you can say, I'm sorry, I asked a yes or no question. I don't want to be here all day. I just want to know yes or no in your witness statement. Did you ever say you were scared for your life? Did you use those words? No. You know, so kind of coming back to, okay, I don't want to waste time here. Those are, it's good little things, little quips to say to try and control the witness gently. If you're having a hard time with the questions, I like to always, a good one is yes or no, you feared for your life. You know, like that is a very, or true or false. You feared for your life. But, you know, that they either have to say true or false. If they still are trying to hem and haw, or they try to explain or keep explaining, yes, but is when you, that's when you actually can object to the court and say, I've asked a yes or no question, you know, they're being non-responsive, or they're launching into, you know, something, you know, testimony that I haven't asked them. So usually you can say, I'm objecting that their answer is non-responsive when they just aren't going to give you, they won't answer a simple yes or no question. Then you can ask the judge to strike their prior testimony, and then you can ask the judge to instruct the witness to answer the yes or no question. If you're going to ask the judge to do that, make sure that your question is perfect, yes or no. Don't make it up on the fly, or know exactly what it's going to be, you know.
Yeah, and I will add to that, Stacy, as a presiding judge, it's very helpful if the witness is being difficult and you say, I'm going to ask you a yes or no question. Were you afraid for your life? Because if she says anything other than yes or no, it makes it super easy for me to sustain a non-responsive objection.
Yeah.
Because what I see teams run into is they're not actually asking yes or no questions.
Right.
And then they want to objection non-responsive. It's like, well, she's actually answering the question you asked. Maybe ask a better question.
Yes.
So that can help if the witness has not really answered, is to step back and go, this is a yes or no question. Were you afraid for your life?
Yep. Absolutely. And because I actually had one time at trial, a witness that was just didn't want to give anything, like even statements that no one cared about that were in a witness statement. It was just really challenging. But just thought that her job was to just fight me on everything. And so during cross-examination, it was a struggle because there was a couple things I needed to get out, but after doing it and being reasonable for so long and asking good questions, finally the judge just started ordering her answer the question or be held in contempt. I mean, it was, you know, so this is where when you phrase your questions clearly and ask them correctly, the judge is going to be on your side.
Right. And for purposes of this competition, also, if you are asking these beautiful, perfect yes or no questions and the witness is still dodging, that affects the witness's score.
Yeah.
So as the witness, keep that in mind, that sometimes it's actually just better as a witness to say yes, no, and not try to detract, not try to waste time or do any of those things, because it does affect your witness score.
Yep. Like I said previously, you know, so know what the points are that you either need or want to establish on cross-examination. So I think, you know, like we talked about for the defendant, it's important to establish that neither of these witnesses, you know, were scared for their lives, and no one told, like, they didn't see anyone else that was scared for their lives, or they didn't say so in their statement. So, you know, that's a point that should be made. But once you've done that, like, there's lots of things that you can just kind of like, you could go through and just kind of argue with lots of things they say, but if it's not relevant to these elements we're trying to prove or to credibility, just sit down, be done with it, make your points, and sometimes that's all you can do. You can introduce exhibits during cross-examination. Great to do it if you can. And during cross-examination is also the time when you would impeach a witness. That is something that happens when a witness directly contradict, there's a document or, a prior like sworn statement that the witness has made before that directly contradicts what they're saying. If you see it in a mock trial case, it will be probably purposefully put in there. Or the other way it would happen is like basically a mistake of a witness saying something. So when they're purposeful, the way you impeach a witness is you have to get them to absolutely commit to the statement that you're going to contradict. Like repeat it back to them. You testified you were scared for your life, correct? Yes. Great. Then what you do, for example, if you were bringing up the sworn state, like the fact statement that, didn't have that in there, or if, for example, they said, I wasn't afraid at all, I ran right in there. That's when you laid the foundation, like, have you made a prior sworn statement? Is this it? It is. Okay, can you please read along with me this line? I was not afraid at all. I ran directly into the room despite the tiny fire. That is impeachment. It is basically showing that the witness is not credible. Sometimes it's a good thing to just impeach a witness just to show that they aren't credible. Sometimes you want to impeach the witness to show that what you're trying to show is true. Basically, it doesn't really matter. It will always go to their credibility because it shows an inconsistency. But it sometimes just goes toward how much you want to fight to make the point, and use that. So
yeah, and I will also caution, don't be super aggressive and rude when you're impeaching, because my experience at mock trial is that it's almost always a witness mistake. They are not intentionally dodging it. Like in real life, Stacy and I deal with witnesses who absolutely lying flagrantly, and
yeah.
That's when we start getting a little aggressive and a little bit more pointed. But in the mock trial competition, just do it very politely, professionally. It is, and I will say a good chunk of the time, as soon as you say, well, didn't you give a previous fact statement, you see the witnesses' wheels start turning, oh, I think I just misspoke.
Mhm.
And so being super aggressive on an impeachment is not going to get you extra points. It might actually just affect your professionalism and presentation.
Mhm. Yeah, absolutely. And so especially when it's a situation like that, you've impeached them, the contradiction itself speaks for itself. So as long as you've done a good job of laying out those things, like the statement and the contradiction, then you just sit down. It's happened. Okay. I think that is most of what I wanted to go through for purposes of direct, using evidence, and cross. Was there anything specific that you guys had questions about for writing these types of questions, how to handle witnesses, things like that? Oh, so I did get a question. You can lead in cross. What happens if opposing counsel objects? And so objections are something that they're a little bit beyond the scope of what we're going into today. We will share materials for you. They are based on the mock trial rules of evidence. But at the end of the day, if the opposing counsel objects, to listen to what they say. They'll say, objection, hearsay, objection, it's not relevant, objection, I don't know, they haven't laid the foundation. So listen to what they say, then the judge, sometimes the judge literally will just kind of be like, that's not a thing, and won't even ask you to answer, but the judge will ask you to respond to their objection. Typically you can kind of respond a little bit based on what they said. If they said that's not relevant, you'd say, this is relevant. It goes to whether or not the defendant intentionally burned something in a public place. And if you'll ask me to ask a few more questions, the relevance will be established. Something like that we had talked about earlier. But I would recommend just responding as quickly as you can. Keep your composure. That's the most important part when dealing with objections. And then the judge will say, sustained, overruled. If what it means is if there's an objection that is overruled, that means the objection was denied and you may go on with whatever you were asking about. If the objection is sustained, that means the objection lives. And so you either have to move on to a different line of questioning, or the judge will say rephrase your question, or move on to a different topic, counselor, something like that.
So somebody has asked, what is redirect and recross? And I think the answer simply is, if I'm the prosecutor and Stacy is one of my witnesses, my direct is when I'm asking her what happened, who, what, when, where, why, blah, blah, blah. Defense gets to ask her cross-examination questions. I will then have a chance to redirect her, but that's going to be limited to whatever came up in cross. So if on cross, they really drilled her about, okay, but you saw him set the fire, but did you know he intentionally? I might come back and say, how do you know he intentionally set it? And it's well, I saw him pull out his lighter and put it on the flag and start the fire. I might just re-highlight something because I want that to be really the last thing that the jury hears from this witness. And then recross would be the same thing. If they said something on redirect, you just want to clarify. Redirect and recross are optional. You don't have to do them, but they can also highlight that you're really listening to the questions, that you really know your elements and you really know what's important and what's not important. Can you present the witness with evidence, exhibits, and cross? Yes, we've discussed this. Stacy pointed out it's a little bit harder on cross because the witness may not answer your questions yes or no directly as much as you want them to. You cannot, witness statements can be used for impeachment. They cannot be admitted as exhibits. And Stacy, what are some common mistakes you see during either direct and cross?
So I think with cross-examination is not having your questions tight enough. So if you want to, let's see, if we're going back to that causing persons to be in fear for their lives element, yes or no, were you in fear for your life? You need to make it as clean and crisp as possible. So really, if it's a very important point that you want to establish on cross, then get your questions really tight. You can readjust on the fly. The other thing with cross-examination is getting kind of flustered, because it does get it's much more, I guess, combative than a direct examination would be, right? So kind of keep your cool, keep your composure, take a breath, kind of slow down the rate of speaking, and know when to move on. There's just a time where it's even if you I've seen many times, you spend 5 minutes going back and forth with this witness on kind of an issue that's kind of important, but and even if you won at the end, no one noticed because they were just bored or annoyed. So know when to make your points and sit down and be done. I think on direct examination, really, I think sometimes people just lose sight of what elements you need to establish, what parts of the testimony are important. So one way that you can highlight those as the attorney is called like threading. And essentially what it is you are going to repeat back like important, something they said that was important that you want the jury to hear again. So, you know, so because you were afraid for your life, what did you do next? You know, you testified that you were afraid for your life. What happened after you ran out of the room? Some, you know, something like that, where you, that's the only time where in direct you should be highlighting something, or like really like as a lawyer, like speaking in a way that you want people to really hear. I think on direct, having a clear roadmap of where you want the story to go, rather than just, you are to some extent going to be following the fact statement, but you need to do it in a controlled manner to prove your points, not just to kind of rehash a story. Because there's a lot of things that aren't important. I think for like in this sample case, there's a lot of like hemming and hawing about what flag was burned and whether it's a constitutional right or this or that. And like that, none of that is relevant to whether people were afraid for their lives and he intentionally caused them to be afraid for their lives and cause a public danger. So, you know, you can have that stuff in there, but if you aren't doing a focused direct exam, you're going to, you know, your points are going to be lost.
Yeah, and I would add on direct also, a little bit on cross, but mainly on direct, I see this is if you know you're asking like a question that's about hearsay, but it falls under an exception, have a note to yourself and know your exception and know that the other side is going to object to hearsay because they want to show the judge that they recognize it's hearsay, and be prepared to say, well, this is the exception. And I also recommend going through each and every one of your exhibits that you intend to present and think about what objection would I make to this and what is my response to this objection so that you're ready to present it. Because nothing makes me break my heart a little bit more than when an objection is made and no one has expected it. Everyone has the same case materials. You need to be looking at it not only from the prosecution point of view, but from the defense point of view. Like, I don't want them to be able to say this. What's the objection I would make? And then as the prosecution, you would say, well, my response would be, this is an exception because it's a surprise or whatever. What's there's a one where you're like excited utterance. There we go.
Yes, excited utterance.
It was an excited utterance. Or, well, you know, it's opposing party statement. Like if you're a prosecution, like you can absolutely bring in the defense statements, right? But keeping in mind that like on the defense, like the prosecution is the opposing party, not any of the witnesses. So that doesn't necessarily apply the other way. But there may be statements against interest. You know, there may be statements that you're not showing to prove that they said it. You want to show how they reacted to this statement. You're really trying to get into why, in this case, the colonel of the guard, why did you run into the room? Well, because I got a phone call telling me something was going on. Okay.
Yeah. Yep. It's not, so I guess do you guys want us to like quickly review hearsay? I think that's one thing that you're going to get into, you're going to hear. If we can kind of give you a quick overview, I think we're happy to do that. Otherwise, we can just kind of go through some more questions.
One of the questions in chat is, when can you make a leading objection? So leading is not just a yes or no question. Leading is a question that suggests the answer. So if I ask Stacy, well, did you hear the defendant say anything? That's a yes or no question, but not necessarily leading, right? But if I say, well, didn't you hear him say, I'm going to set fire, you know, like,
oh, I did. Now that I think about it.
Yeah, the defendant, you know, it's an opposing party statement, but I'm still suggesting the answer to Stacy, where the question is, what did you hear the defendant say, right? That's when I want the witness to say, I heard him say, blah, 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 blah. So absolutely, if you hear a leading question when they're directing, again, on cross, lead, you want to ask those yes or no questions. You want to suggest the answer because that gives you control over the question and the answer that's being asked. And then Stacy, one other question I got is, can you ask witnesses about other witness statements? Can we assume that they've read them?
Yes, I think in the trial, especially, one thing that's always on the table is that if a witness has testified you can absolutely say, you were just in the courtroom when, Jessica testified. Yes, I was here. Did you hear her testify about the accounting ledger? I did. She said there were some mistakes. She did. Can you explain those? Oh yeah, those were not really mistakes. That's just like kind of what we do is we note this in this field. And so I can absolutely explain that for you. That's an example of how you might do that.
Yeah, but you would not go, yeah, I heard Jessica testify to this, but her witness statement said something else. Unless a witness statement specifically said, I read X's witness statement, the assumption is that they have not read each other's witness statements.
Correct.
But but if someone has already testified, you can assume that they heard the testimony.
Yep.
Those are all great questions.
Yeah, these are really good questions. I think with the reading other witness statements, part of the reason why you wouldn't really want to go there anyway is because another witness's statement is going to talk about what that other witness knows. So your witness can't testify about that anyway. She can only testify about what she knows and she heard and saw. So she'd simply be saying what someone else saw and heard and knew, and that's not her personal knowledge.
Yeah, and I will just say for the purposes of practicing and training, if you're spending a lot of time reading someone else's witness statement and not yours, you might start confusing the facts.
Yes.
And so if you're gonna be Nikki, you're going to be witness Nikki, you really want to spend most of your time reading Nikki's statement and preparing for what questions you're going to be asked as Nikki, because if you start reading the Colonel's statement too much because you're trying to like poke holes in his, you might start going like, oh, I don't really remember what what Nikki would say here. I'm remembering what Colonel would say. And I understand like most people are going to be playing two witnesses. You're going to be playing a prosecution witness and a defense witness, and that's fine. But if you start reading too much of like, all three prosecution statements, that's when we start seeing things blend together in a way that's like, oh, well, are you remembering the correct facts or not? But you can by all means, because you want to help each other prepare and train and all of that. But I wouldn't spend a lot of time trying to memorize facts of other statements in a way that you can go like, yeah, her statement's wrong and his statement's wrong, and I don't like what that person said.
So I think we have a little bit of time. You guys have heard us mention hearsay. It's a difficult concept, but it's something that will come up. So I'm just going to give you the high level. So hearsay is an objection, saying that some evidence or testimony should be kept up because such evidence or testimony is being an out-of-court statement being offered for the truth of the matter asserted. So an example is, I'm testifying, I'm the witness, and I said, well, Jessica said that the package was delivered Friday. Jessica's not in court, and I don't know that the package was delivered Friday. All I know is that Jessica said that, and there's no other real way. So that is an out-of-court statement, and assuming I'm trying to prove that is true, that it was delivered on Friday. So when the witness is saying that, or when a question's asked in that manner, the attorney that's doing cross for that witness would say, objection, hearsay. It is an out-of-court statement being offered for the truth of the matter asserted. So your job, if you really need to get that in, is to go through and pick out one of the exceptions to hearsay. Those are written in the rules of evidence. I think rule 804. Anyway, you can go through those and there are exceptions. Or you can say, if, for example, you don't need it to be true that the package was delivered on that day, you can say, I'm not offering it for the truth of the matter asserted. I'm offering it to show that I assumed it had been delivered, and so I didn't I didn't send another package out, something like that, to show like what you did next and why you assumed, you know, how that impacted you. So it doesn't have to be true. It just is why I did something, how I reacted, I guess is what I mean. So that's just a quick kind of primer on what that is and how you respond to the objections. That will require kind of some learning on your part about hearsay and the exceptions to hearsay, but at a conceptual level, a lot of the exceptions to hearsay are something that makes it so, makes this out of court statement kind of so authentic that we can believe it might be true anyway, or it's likely true when it was said. So we talked about an excited utterance. So that's a good example of, you know, I heard Jessica exclaim, "Oh my gosh, he fell off the ladder." You know, that is, Jessica's statement is an out of court statement. I'm offering it for the truth of that guy fell off the ladder. I need that to be true, but it's an exception to hearsay because it's an excited utterance. She was excited when she said it. It happened right as this guy was falling off the ladder. And because she was so shocked and excited, we can, you know, we have these beliefs that these are an exception to hearsay and are authentic. So that's kind of like an exception. That's an example of one exception.
Right. And if you know something is an exception to hearsay, you can sort of front load your question. Like, okay, you heard her say something. When did she say it? Immediately after. How did she sound when she said it? She was exclaiming in shock. She was like yelling it, or, you know, going back to our flag burning. If there had been a random person in the audience who said, "Oh my God, we're all gonna die,"
right.
You might get excited utterance if you can say, "She screamed it. She seemed terrified. The look on her face showed, you know, like, what did she look like? Blah, blah." Okay, so now what did she say? So we've already established there was some excitement, that it happened immediately, all of that. So when the other side says objection hearsay, you can say, I believe the foundation that it's a excited utterance, Your Honor.
Another one is like a dying declaration. So like someone's on their deathbed, essentially, like, you know, similarly, you'd say, okay, you heard her say something. Was the knife in her chest at that time? Yes. Was she bleeding and in pain? Yes. At the time, she was like in pain, bleeding, and trying to say something. And then what did she say? "How could you do this, Mom?" You know, that is how you, then you, if there was an objection, you'd say, this is the dying declaration exception to hearsay, because at the time she was dying.
The question in the chat is, would a witness offer this explanation for hearsay? Only if the attorney has asked you those foundational questions. But if an objection to hearsay is made, it is the attorney's job to argue why it is an exception or why it is not hearsay, because there are things that are not hearsay. It's the attorney's job to make those arguments, because again, if an objection is made, the witness's job is to say, stay silent, stay out of trouble.
Yes. One thing also when you're handling objections, this was one thing I did wrong at my first mock trial. And you are always, even if an objection, you know, is the opposing counsel, it's your witness, the objection is raised, all of this discussion goes to the judge in the court. You are always addressing the court. So do not turn and look at opposing counsel and start explaining why it's not, or what have you. You are always addressing the court who is deciding on these matters. Oftentimes do not speak unless the court looks at you and either asks you to respond or kind of gives you the nonverbal, like, say something. So just in terms of decorum, that's really important. I got in trouble for trying to argue with my opposing counsel and not tell the court.
And if you're and again, if you're pretty far into a witness and we've made the same objection several times and the judge just let you argue it, me as a presiding judge, I may just go ahead and rule. And if you start trying to butt in to explain, it's not going to deduct points, but usually as presiding judge, I'll say, like, I've heard your arguments about this particular objection. Like we don't need to hear any more arguments about it. And so like if we've made leading objections 6 or 7 times and I've already overruled all of them, I might just continue overruling them and not allow anybody to argue about whether or not it's leading.
Yep. Absolutely. Listen to whenever the judge makes a comment or says something about your questioning or your witness, listen to them, look at their body language. You know, if you keep asking questions that, you know, they've sustained and then they're getting annoyed, think about what maybe you're doing that the judge told you not to.
Yeah, I will say at state competition this last year, the only time I really got annoyed as presiding judge was I had one particular witness who kept trying to argue about objections, and I finally had to instruct her to stop talking. And I will tell you, she lost points for that.
Yeah.
Because it's not the witness's job to make those arguments. Even if you think the argument is nonsense, especially if it's like objection non-responsive and you as the witness are like, I definitely responded. Keep that thought inside your head. Let your attorney advocate for you. It's their job. And the judge will hear that. And ultimately we're not necessarily scoring on whether or not the presiding judge sustains or overrules. Sometimes, quite frankly, we rule the wrong way to see what you do. Or just because we want to let a question in, right?
Yeah.
Technically that was leading, but I want them to answer it because that's a really key fact. And I want to see how the witness answers it. And so remember that you're not being scored on whether or not it's overruled or sustained. You're being scored on the quality of the objection and the arguments you make in response to objections.
And then how you handle what happens next. Yes.
Okay.
That happens in real life. Absolutely.
Yes. We have some kooky judges on the bench these days who sometimes you're just like, as the attorney, you ultimately just have to stay out of trouble. It's like, you're not going to rule correctly. I'll keep making the objection. I'm going to move on with my life. So we are at noon. That's our stopping point. Thank you guys so much for attending. Again, these are recorded. We're going to put them up for you guys to watch them. If you have any further questions that you don't feel like the rules of evidence or the rules of the competition address or aren't in the case materials themselves, you're welcome to send those through to Melissa, and she can get official rulings if necessary. If there's any case clarifications, we do occasionally post clarifications for cases as we go along. And so you're welcome to send those, and any other questions that we can answer for you, you can send those to Melissa. So we look forward to seeing y'all in competition this year. We're so excited. Where would the recordings be located? My assumption is that they're going to be on the main page where the materials and all of that are posted, but they may also end up going just on the YouTube page. And that's really going to be a Melissa question. And so I will let her know that y'all have asked that question, and so she can send that information out. But thank y'all so much. You are now free to go.
Have fun.